Justice Lowy is participating. We're having visual problems with the camera, so he is participating as well. Chief Justice Gantz is with us virtually and will participate in these decisions. So with that, I would ask Clerk Hingham to call the case.
SJC-12891, Liz D'Alessandro and others, v. Lennar, Hingham Holdings, LLC, and others.
Mr. Weld.
Good morning, Your Honors. My name is Christopher Weld. I represent the defendant, the Lennar defendants in the United States District Court case. The answer to the special question is governed by the language of Chapter 260, Section 2B, and the legislative intent behind it. In the Stearns case decided just last year, this court made clear that the language of the statute is clear and unambiguous and is conclusive as to legislative intent. The clear legislative intent is to protect construction professionals by limiting their liability for design and construction defects to 6 years after completion of an improvement to real property. Chapter 260, Section 2B bars claims sounding in tort for the design and construction of an improvement to real property after 6 years from the earlier of the opening of the improvement to use or substantial completion and taking possession of the improvement. The term improvement to real property is not defined in the statute. However, in the Mulligan and Dighton cases, this court has adopted the Webster's Dictionary definition of an improvement. In this case, there are 3 standalone buildings built in phase 1 of a condominium project. The second phase encompassed 2 standalone buildings, and the 6th building that was the subject of the underlying motion is 1 building in phase 3 of the underlying condominium. There were 24 phases and 28 buildings. For each of the 6 buildings in question, the architect issued a separate certificate of substantial completion, and the town issued a certificate of occupancy. These buildings were thereafter occupied while construction continued. The master deed provides that the developer had no obligation to construct any further elements of the condominium past initial phase 1, and the additional phases were done by individual amendments, usually on a building by building basis. When we apply the Webster's definition of improvement that the court has adopted to these improvements, or these elements, if you will, structures, it is clear that each individual building and certainly each phase is in and of itself an improvement. There are 5 elements in the definition. First, these buildings were clearly permanent structures. Second, they certainly enhanced the capital value of the real property, as each contained a number of condominium units. They certainly required the expenditure of labor and money to complete, and they were designed to make the property more valuable. They certainly were not ordinary repairs. Accordingly, it is clear that each individual building, by the definition adopted by the court, is in fact an individual improvement. This is consistent with the legislative intent, because under this formulation, or frankly, just
excuse me, Mr. Weld, I have a question, Mr. Weld. The question I have first is, what happens though, it seems to me that the certified question is quite fact dependent here. What happens though when the facts change? In this case, of course, it's a matter of the same developer, seems like the same architects, the same contractors are involved with the entire, all the multi-phases. What happens if that's not so? Suppose it's a different developer, suppose it's a different architect. So how does this work?
The definition that was set forth in the statute in Stearns does not focus on who the actor was, who actually performed the work. It focuses on whether there's an improvement and whether it has been substantially complete and ready for occupancy. In fact, in 1984, the legislature amended statute of repose to go away from a standard that was based on who was performing the work and whether they had completed their work, and instead changed the trigger to the status of the actual improvement. In other words, whether it was substantially complete and ready for occupancy. So in fact, who the actual developer was and who the contractor was is irrelevant to the analysis under this statute.
Although it seems to be certainly part of the certified question, doesn't it?
Well, I think that the court, actually, the district court, indicated in her opinion that a factor she considered was that there was continuity in this case of the developer and contractor. And I suggest to this court that that was error under your previous decisions and under your interpretation of improvement to real estate. And in fact, the cases that are cited by the court, which are primarily New Jersey cases, Ohio, North Carolina, that were also in the briefs of the trust, they use the standard of focusing on whether there was continuous performance, and the trigger event for the statute is in fact when the contractor or developer completes its performance. It's not triggered by status of the physical construction. And again, that was amended in 1984. So I believe, or our position is that the district court was in error in using that type of analysis, and it should be rejected.
Okay, let me ask you another question. How does it work when, for example, you know, I understand how you're saying that there's these independent buildings, and you want it to be building by building. What happens, for example, if in a phased development, in a place where you have to have well water? It doesn't affect the, there's nothing to complain about with the first phase. It's not until you get to phase 14 or something that the well water is really a problem because the water table is altered by the continuing development of the, what would you say to that?
I would say that the where there are elements of the development that are interdependent with other improvements, in this case, other buildings, that in and of itself is an improvement. And the case law supports that conclusion.
I'm sorry, I don't understand. What's the improvement? What is the improvement? The interdependent thing? Or where? I'm asking you what happens. How does the unit owner complain? When is the unit owner able to complain about this?
Obviously the statute of repose sets the outer limit. In this case, the unit
So
owner.
it could happen. Excuse me. I'm telling. My point is that you got 6 hours, 6 days, 6 years for the statute of repose. Suppose that the well water doesn't get changed until year 8 of the development. What happens then?
That I believe that the well water system, which would presumably be distributing the water, that would be interconnected with the entire development.
Yes, exactly right.
So that improvement would not be substantially complete and ready for its intended use, which its intended use is for all of the project. That improvement would not be substantially complete and ready for its intended use until the entire project was complete, when all buildings could have access to it. So
Okay.
each one of these things is in and of itself an improvement. We must look to what its intended use is and how that use is activated to determine the trigger event for the statute of repose.
Okay. Let me continue on to ask you about how do you respond to the contention that your approach encourages piecemeal litigation?
Well, I think primarily that's a legislative decision, that the legislature made clear what the trigger event was and what an improvement is, and particularly this court's determination in Stern makes that clear. Further, the statute of repose is the outer limit of when a lawsuit can be brought. And I would suggest to you that in a multi-building complex, if you have a systemic problem, you're going to start to see it early on. And therefore, you're going to do an investigation. The first building that shows a concrete problem, a window problem, a water infiltration problem, that's going to allow you to then do an investigation. Further, even to the extent there were multiple lawsuits filed, they certainly would be consolidated, and presumably if people had to be added or there were additional claims, it could be done via amendment. So these are all things that can be procedurally addressed by the current tools available to the court.
Okay. Now you mentioned legislation. There is pending legislation that could change all of this, isn't there? Hello?
I'm sorry, I didn't hear the question.
I'm sorry. There's pending legislation, right?
No, there was a legislative change in 1984.
No, I meant there's pending
Yes.
legislation now, isn't there? Isn't there pending legislation now that would change the statute of repose?
I'm not aware of it.
Oh, okay. Not aware of, not aware of the legislature's July 16, 2020 House engrossing enacting Bill 4605, an act relative to construction defect claims by condominium owner? You're not aware of that?
No, I'm not aware of it.
Okay. All right. Well, I'm going to turn it over to my colleagues then.
Well, let me ask you, Mr. Well, the same answer you gave to the question posed by Justice Lenk regarding well water, how would that apply to common buildings? Defects in the clubhouse, for instance, that's supposed to serve the entire condominium.
The defect to the clubhouse would be the statute of repose would run from the time of its completion, which presumably would include when it could be actually used by somebody.
By someone. It wouldn't be that the clubhouse was supposed to serve the entirety of the condominium project?
I think that would be also a reasonable interpretation to say that in the context of a clubhouse or a pool or those instances that is integrally connected to the entire condominium project. So therefore the statute could run from the completion of the entire project because that's when it could be used for its intended purpose. But the individual buildings are already occupied and used for their intended purpose.
Justice Kafka.
It's a follow-up to the same questions that Justice Lenk and Justice Gaziano asked. So I've got a two-building entity, and they build the first building, and the foundation's not proper, but we don't find that out until the second building shifts the land on it. And that happens more after the statute of repose on the first building expires. How would this work? How would the people in the first building be protected in that context?
They wouldn't be.
So they would be left with, so their building starts to, tilt like the Leaning Tower of Pisa. And it has nothing to do with the fault of the second building. It's just that the first building was done improperly and they wouldn't have any means of recovery at that point.
No, I think that once they have a certificate of occupancy and a certificate of substantial completion, under the plain language of the statute in the Stearns decision, the statute of repose begins to run at that point. They have a 6-year limit. If they discover the defect after the 6 years, the legislative determination is that the 6 years is a proper balance and that they're out of luck. And I think that's essentially what the Stearns decision says, Bridgewood says, and many of your prior rulings.
Thank you.
Could I ask another question?
Certainly.
Okay, going on along with those, along the same lines there that you just discussed. Suppose that I think that Justice Kafka's point was that the defect didn't really happen until year 7. And you're still saying that there's nothing that the unit owner can do at that point?
I'm not sure what I understand the defect is.
Okay, the defect, the things, it doesn't get moved until the land underneath the unit 1 doesn't get moved until unit 2 is completed. And unit 2 is not completed until 7 years after unit 1 is completed. Is that not your question, Justice Kafka?
Well, I was going to pose it in 2 ways, but the first way was I thought there was a defect in building 1 up front, but no one discovers it for 6 years because it's fine until they start moving the foundation in building 2. I was going to reverse the question and say, okay, building 1 is fine for 6 years. And the real problem is that building 2 is misconstructed, but it ends up causing damage to building 1. I'm just trying to understand both scenarios.
Yeah, good.
But it sounds like,
I think that if there is a action by a contractor on building 2,
right,
that causes damage to building 1, that would not be an action arising out of the improvement to real property that is building 1. So it would not be precluded by the statute or it would not be precluded by the passage of the 6 years because this is a new event related to a different improvement.
Yeah, but what I was, in my first hypothetical, I was contemplating that there was a defect in building 1 that doesn't show up for 6 or 7 years until building 2 starts moving the foundation. And it's the same developer, but you're saying building 1, the owners of building 1 are out of luck in that context.
I believe that's the correct interpretation of the statute.
So may I ask another question?
Certainly.
How reliant are you on the certificate of occupancy to determine substantial completion?
Well, I think in this case, the facts are that there is both a certificate of substantial completion and a certificate of occupancy.
Okay, that's here, but I mean, how reliant are you on this theoretically?
I think under the statute, you have a two-prong.
Alternatives, there are alternatives, right?
Yeah, it's an alternative. It's the earlier of the opening of the improvement to use or substantial completion and the taking possession of occupancy. So it's an either or in the earlier governs.
All right, how do you prove number 1?
I think that would primarily relate to a common building
Common building.
where you're not going to have technical occupancy, for example, a pool, the clubhouse example, but where it's open to use, that would be the trigger.
Okay.
And I think that could be evidenced by a number of things, including a certificate of substantial completion, a formal opening by the condominium association, a certificate of occupancy. All those things might bear on whether the improvement is open to use.
Okay, thank you.
Thank you, Mr. Weld.
Thank you.
Mr. Gorman.
May it please the court, good morning. My name is Hugh Gorman. I represent the Board of Trustees of the Hewitt's Landing Condominium Trust. They are the elected group of unit owners who are responsible for the management and control of the common areas and limited common areas of the Hewitt's Landing condominium. The trustees are the plaintiffs in the federal court and the appellees in this matter. Your Honors, the resolution of the certified question that Judge Talwani has sent to you hinges on the word improvement and how that is defined or how it is interpreted relative to the statute of repose. I suggest that Judge Talwani has submitted a very narrow and discrete question to be answered based on the very specific set of facts in this case. The Lennar entities are sophisticated. They are one of the largest home builders in the United States. Between November of 2009 and June of 2015, Lennar, in accordance with its master deed and wearing multiple hats, and the multiple hats that it wore were owner, developer, construction manager, general contractor, and trustee of the condominium trust, acquired, planned, marketed, and built the condominium. Lennar's counsel referenced the master deed that Lennar recorded in connection with to basically create this Hewitt's Landing condominium. That master deed was recorded on October 25, 2010. It serves as both the condominium's birth certificate and the roadmap as to how Lennar planned to, and in fact, did build the Hewitt's Landing condominium. That master deed, Your Honors, which appears at the record appendix 2 at page 7. In that master deed, Lennar created a single condominium. It didn't create 28 separate condominium buildings. It didn't create 150 separate condominium units. It created, by that document, a legal entity pursuant to the condominium statute, chapter 183A, a condominium. It states Lennar's intention to build the condominium, not a series of buildings, not a series of units, the condominium in phases, each of which will be part of the condominium. Equally important for the analysis is that that master deed grants appurtenant rights to all of the unit
But
owners.
the master deed is not what the statute refers to, is it?
Your Honor, you're correct. It doesn't, the statute doesn't refer to the master deed, but the master deed is instructive with respect to the analysis of these very specific facts in a phased condominium relative to the statute of repose.
Are you saying we're not supposed to answer this more generally?
I am, Your Honor. You've been
We're
given
supposed to just limit this very limited question based on these very limited facts. That's all we're supposed to do.
Yes, Your Honor. These limited facts where you have a owner, developer, general contractor that wears all the hats and builds one unitary development, start to finish, cradle to grave.
But the statute does not define improvement to real property. And that's really what this is all about, isn't it? What is improvement to real property?
I'm sorry, Your Honor. You're correct. There is no definition in the statute of the term improvement. And Your Honor, the cases that were cited, the Dighton case and the Milligan case, confirm that there's no definition of improvement. They also state in their reasoning that the legislative history of the statute of repose provides a dearth of information for reference to indicate what the term improvement means. And in general, your court has held that the Webster's Dictionary definition of improvement can be used to assist in interpreting what the term improvement means.
I think Justice Kafka has a question.
Sure, thank you.
Are you done? I don't want to cut you off, but Justice Link, are you done?
I am.
Okay, I don't understand your argument, Mr. Gorman, very well. When I look, we've got to interpret this statute. So, and I'm reading, precludes recovery against those within its purview for any injury that occurs more than 6 years after the earlier of the dates, the opening of the improvement to use, substantial completion of the improvement and the taking of possession. We got a building that's open for use. And there's not even a requirement that there's going to be another building. Nonetheless, we still don't find that this is triggered at that point. I don't get it.
Let me try to explain my position, Your Honor.
Mm-hmm.
With respect, this is not a building. This is a condominium.
Well,
We're not.
The word is whether it's an improvement, right?
Well,
it doesn't say the word building. It says improvement, right?
but Your Honor, Lennar set its own guidelines and roadmap as to what it was building out there. The improvement is the condominium development in toto, not a single building. And if you would let me expound on that. With respect to condominiums and the condominium master deed, when you're a buyer of a condominium unit, you buy a unit at a time certain, and at that time certain, you also get a percentage interest in the appurtenant rights of the condominiums, of the common areas of the entirety of the condominium.
But Mr. Gorman, we're living, we're dealing with sophisticated real estate transactions, right? It can be 20 years before parts of these things are built, 30 years, right? Real estate goes up and down. And the condominium owner who's in a building is not worried about building 3, right? They're worried about their own building. Unless building 3 starts screwing up their own building, that's a whole separate problem that I'm worried about. But it just seems like there's no requirement and not necessarily even an expectation that we're going to have 25 buildings here. Is there?
No, Your Honor, I respectfully suggest you're incorrect. If you look at the master deed states that it's going to be built in phases, that it's going to be multiple buildings, that it can be up to 150 units. And the master deed itself, Your Honor, gives Lennar 15 years to complete construction of the condominium that it formed. So, Your Honor, with respect to a period of years, Lennar certainly gave itself 15 years to build the Hewitt's Landing condominium in its master deed. It didn't avail itself of those 15 years. It only took them between 2010 and 2015 to build the entire development.
Just trying to understand. So, because again, we're not, a district court. We're ruling sort of on, our ruling is going to control lots of different construction projects. But you're saying that we're going to define improvement by the master deeds every time, or the particular contract.
That's not what I'm saying at all, Your Honor. What I'm saying is the master deed provides reference for the factual context by which the court arrives at the conclusion that the improvement is the entire condominium development. And I'm not saying that master deeds need to be referenced, and nor am I saying, and again.
But bear with me for a second, Mr. Gorman, because we don't decide just specific cases here. We're deciding what this statute means. Are you telling us that the meaning of improvement in the statute is going to be defined by each one of these master deeds or construction contracts? It's all going to be dependent on the particular language in these contracts. Is that what you're saying?
I believe what I'm saying, Your Honor, is it's dependent on the facts of each circumstance. This is a condominium. This was built as a phase condominium. It's a single condominium. It's not a series of condominiums. Lennar made its bed when it filed the master deed in this scenario and defined what it was creating and what it was going to build. It set all the limitations in it as to what it could and couldn't build, how long it was going to take to build it. It also reserved the right for itself to stop building the phases at any point in time that it so determined. And it could have relinquished the rights to build additional phases.
May I bring you back to one thing you said in answer to Justice Kafker's question? You go back to the master deed. However, the question that's been certified to us calls it the construction of a single condominium development comprising multiple buildings or phases. Isn't that slightly different than just calling it a single condominium?
Justice Seifer, I don't believe that it's different. I think what Judge Talwani has concluded is that Lennar built this project from cradle to grave. It formed the condominium as a single standalone condominium under the 183A of the general.
But the word development is in there, so so that doesn't modify it at all. You're saying we're just cut as it is in the statute.
I believe, Your Honor, that what the court was referring to when they say condominium development, in layman's parlance, when you say condominium development, I think development is an amplifying word, but I think what it means is condominium. And there is no dispute that there is but one condominium down on Hingham Bay. That's the Hewitt's Landing condominium.
Okay.
Justice Lowy has a question.
Sure, thank you. Mr. Gorman, I recognize that we don't have a certified question concerning subcontractors, but Justice Kafker's point about that despite the factual vacuum, we're talking about broad points, and I'm concerned. What about the situation where the subcontractor finishes the work completely in 2020 in Building 2, but Building 5's not done until 2026? How do we address the specific issue here without commenting on a lot of possible factual differences, such as subcontractors?
Thank you, Justice Lowy. I think what you're asking me is, can different entities have different statutes of repose? And my answer is yes, they can. With respect to the Lennar entities here, they built one unitary project start to finish, serving as developer, owner, general contractor, and as the trustee of the Board of Trustees. They did the whole project from 2009 through 2015. In the scenario where you have a subcontractor that was only on the first building at Hewitt's Landing and did not work on further buildings, that subcontractor, for the purpose of that subcontractor, the only improvement that it worked on was that single building. Now, if that same subcontractor built and worked on all 28 buildings, the analysis would be the same with respect as to the analysis I've given with respect to Lennar. But in the limited factual context where you've got subcontractors that work only on a specific building, then their work starts and finishes, and I would argue that with respect to them, they're working on that specific building. But with respect to an entity that works on the entirety of the project, from start to finish, plans it, develops it, and builds it, the improvement is not a building. The improvement is the condominium, which is the entirety of the project here. And one other thing, a point that I did not finish earlier, I was talking about the fact of how important it is that we specify or acknowledge that we're dealing with a condominium here, not a single family home, not a commercial building, not a series of buildings. We're dealing with a condominium. The condominium itself is a legal entity. And I was talking about unit owners and what they buy when they buy a condominium. I may buy a unit in the very first building that was built out here. But when I buy that unit, I own that unit myself. What I also own as a tenant in common with everybody else that buys a unit in my condominium building, in any other condominium building in the project, is an appurtenant right in all of the common areas throughout the entirety of the condominium, whether they're finished at the time of my purchase or whether they're not finished for years later, as we have here, when the last building at the condominium was not completed until June of 2015. And the condo association here is prosecuting a claim with respect to defects in the common areas throughout the entirety of the Hewitt's Landing condominium, not just in one specific building, throughout the buildings. And therefore, my ownership interest as a condo owner of one unit doesn't become completed until the very last item of all the construction at this condominium is completed. And at that point in time, I own, as a common owner with the rest of my unit owner.
But that's not what the statute says, is it? That you're referring to things that the statute does not refer to, aren't you?
Judge, I didn't argue that the statute cites that.
It doesn't.
You can't ignore these facts and apply the statute. These
Wait a
facts,
minute. First, we have to figure out what the statute means, don't we?
well, again, we need to know what improvement means. And my position, Judge, is the improvement is the entire condominium project.
I know that's your position. I want to know when you think that the statute of repose begins to run here. Is it on the last day of the? Is it with the last operative? When is it substantially complete and taken for occupancy or open to use? When is that? When is that statute of limitations? I'm sorry, statute of repose begin to run here? Is the last certificate of occupancy?
I would argue, Your Honor, that the certificate of occupancy for the very last building constructed governs when the statute of repose runs.
Okay.
And that would be a certificate of occupancy that issued for the very last building constructed at the Hewitt's Landing condominium in June of 2015. I know there's been reference to certificates of substantial completion that architects issue. Well, that's all well and good. And again, that is evidence. But until a town.
Don't we have a certificate of occupancy adds to each of these unit buildings?
Yes, you do, Your Honor.
So you're saying it's to be the last one for the entire complex?
Correct, because.
And how do you know when that's going to be? How do you know when that's going to be? I mean, you know, if I'm in unit 1 and there's no unit 2, there's no building number 2 until 7 years down the road, how do I know when that's going to be? How do I know when the last certificate of occupancy, if they're going to be in another phase?
Why do you need to know it? When I buy in a development that's proposed to be a phased development, I think I know as a consumer, and it was suggested earlier, we're dealing with sophisticated parties. The only sophisticated party here is Lennar. The unit owners at Hewitt's Landing condominium, yeah, they may be successful people. They may be sophisticated. They're not developers. They're not contractors. They're consumers. They go out in the world. They're told this is going to be a first-rate condominium.
Under your view, all those contractors, I mean, they remain liable. If you've got some giant project, those contractors are going to remain liable for 100 years. Right? Because there isn't going to be any repose for those little guys that you're worried about forever, right?
No.
In a multi-unit building, they're going to have to worry. Say you're building over a 25-year period or a 30-year period. We have developments all the time that are huge, right? Those individual contractors are going to be on the hook when their grandkids are around.
Are those individual contractors building every building in the unit, in the condominium like Lennar?
But you define improvement as the entire development. If you are correct, they're on the hook until their grandkids, you know, graduate college. So there's got to be some more measured way of defining improvement, isn't there?
I disagree that that's my definition. I define improvement with respect to an entity that builds something start to finish. First of all, an entity that forms a condominium, a single condominium.
You're so divorced from the statute, you're not helping us any.
Again, I'm not divorced from the statute. The statute doesn't define improvement. It's up to us to define it, and I believe that in this fact scenario, I have a reasonable definition of it. I'm not divorced at all. The statute is in fact ambiguous on the issue of improvement. There is no.
Are you aware of the legislation that I was referring to before?
I am not, Your Honor.
Because on July 16, 2020, the House engrossed to be enacted House Bill 4605, an act relative to construction defect claims by a condominium owner. The bill would amend this 260 Section 2B to provide condominium developments with different treatment than other improvements under the statute of repose. Specifically, neither the statute of limitations nor the statute of repose would begin to run until at the latest when condominium unit owners assume control over the condominium. That is essentially what you're arguing, isn't it?
No, it's not, Your Honor. I am familiar with that statute. What that statute, that proposed amendment is dealing with is when you have a scenario where a developer builder also controls the condominium board of trustees, the condominium association, that the statute of repose should be told from running until such time as the condominium association board of unit owners takes over from the developer. The reason for that, for that argument is that in a situation where you have a developer that also controls the condominium association, it may not want to commence litigation against one of its own entities or any of its own subcontractors during the time period that it is out there building a condominium project. It's a different issue than the issue that is before the court today, which hinges on whether or not the term improvement here, as Judge Talwani ruled, is the entirety of the condominium project that Lennar created and Lennar built from 2009 to 2015. If I may go back to the question relative to subcontractors could be on the hook for 100 years. I don't agree with that. Again, Lennar said here, it had 15 years to build this project. It took 6. But Lennar certainly, when it filed its condo documents and created it, knew that it could have up to 15 years to build it and tack on 6 years thereafter for a statute of repose upon substantial completion. That's 21 years. That's Lennar's own decision. That's Lennar making its own roadmap of how it's going to build this project. That's no outside force, no outside entity. It's not unfair. Likewise, Lennar here contracted with all the subcontractors, the suppliers, the architect, and everyone else. Lennar controls its contractual relationships and its rights and remedies vis-a-vis those entities. With respect to a subcontractor, as I stated earlier, that works on 1 or 2 buildings of a phase development and works on no more of them, then that subcontractor, once its work is completed, the statute of repose can run as to that subcontractor. I don't believe that a decision upholding Judge Talwani's ruling on these limited facts is going to reverberate and impact anybody else other than an entity such as Lennar that serves as an owner, developer, contractor, and general contractor in a single condominium project. One other aspect of that is,
Mr. Gorman, you're well over your time. Let me ask if the justices have any further questions of Mr. Gorman.
No.
All right, thank you, Mr. Gorman.
thank you, Your Honor. Thank you, Your Honors.